Hello, in this video, we shall be looking at the defense of Volenti Non Fit Injuria as one of the defenses to the tort of negligence. Welcome once again to the Law Professor, and I would, as usual, enjoy you to subscribe to this channel and like this video. So the defense of Volenti Non Fit Injuria represents the second defense that we'll be looking at. And with regards to this, we want to look at the meaning of Volenti Non Fit Injuria, the elements of the defense, and those things that you should pay attention to from in terms of preparation for exams. If you are looking at answering a question with respect to the tort of negligence that would raise the issue of defenses. Okay, when we say Volenti Non Fit Injuria, we simply means voluntary assumption of risk. And under the law, the principle is that no injury is done to one who consents. If you have consented to a state of affairs and to the risk of a particular injury, then you cannot turn around and complain about suffering that injury. So, Volenti Non Fit Injuria means voluntary assumption of risk by a person, by the plaintiff who is complaining in the facts in the case before you. And it represents a complete defense if the defendant is able to successfully claim that the plaintiff voluntarily assumed that risk of injury, then the defendant would not be liable, quite unlike what we said with regards to contributory negligence. It requires that the plaintiff knew of the risk and consented voluntarily to run the risk. Voluntary consent could be express consent, could be implied from the facts of the case that the plaintiff consented to run the risk of the injury. Now, we said that the plaintiff must know of the risk and must consent to the risk of that, to that risk, and to the probability that that injury could arise. Now, one thing that we must note is that when you talk about Volenti Non Fit Injuria, for instance, if you claim that you were injured during a ride in the defendant's vehicle, and the defendant says that, well, you knew that this vehicle had no brakes. You were there when we complained that these brakes are not going to work, and you still got into the vehicle with the defendant to run through the risk of that vehicle having an accident through brake failure. You cannot really complain and say, oh, this negligence had caused my injury. But the law draws a distinction between knowledge of general state of affairs and knowledge of a defect, whether in the plaintiff, in the defendant, in the vehicle or premises, or whatever is the source of the injury that you are complaining of. Let me give you an example. Every one of us, we know that if you fly a plane, there is the risk of a plane crash. If you walk on the road, there is the general risk of accident. A vehicle will have an accident. This is knowledge of a state of affairs. The fact that we know that a plane could crash does not mean that we will stop flying. That is not the meaning of voluntary assumption of risk. That's just the knowledge of a state of affairs. Okay? But if you knew that the driver is drunk, the vehicle has a brake defect, the plane has one problem or the other, that is when you are now taking to have run the risk, despite that knowledge of getting injured. So then it said, so you see the case of Slater and Clay Cross Limited for that distinction that was drawn. And in that case, where the plaintiff was run over, when she walked through a tunnel, she was run over by a train. And they tried to claim that by walking through the tunnel, she ran the risk of being injured by a train. And the court drew that distinction between the fact that everyone knows, yes, a train could derail. And when you want to walk through a train tunnel, there's that general risk that a train could derail, but that is not the kind of risk and not a violence that we are talking about. That is just a general knowledge. There must be some particular knowledge that makes you undertaking that activity represents the fact that you have consented to run the risk. And Lodeni, in that case of Slater and Cliff, they said that, regarding the lady that walked through the tunnel, when she walked through the tunnel, although it may be said that she voluntarily took the risk of danger from the running of the railway, just like we take a risk when we go onto the roads. Every one of us is taking a risk of being run over by a vehicle. When you work in a particular environment, and there are some risks that are attendant to every activity that we take in life. It doesn't mean that we stop living. It doesn't mean we stop going to the roads. It doesn't mean we stop flying. If you take a ship or a boat ride, it doesn't mean we stop. Of course, that risk is generally there, that there could be a capsizing of the boat and what have you. So when she took that walk through the tunnel, although it could be said that she voluntarily took the risk of danger from the running of the railway in the ordinary and accustomed way, nevertheless, she did not take the risk of negligence by the driver. So the driver, the train driver being negligent was not the risk that she could be said to have been violent about. The rule is therefore Volenti Non Fit Injuria, not Scienti Non Fit Injuria. There must be knowledge of something defective in the item or premises or equipment that caused the injury, or the person that is handling it, such that you said that, okay, you knew that this vehicle was having issues, you knew that the driver was this, you knew that, and you still took the risk of running that enterprise. So the test of knowledge is subjective. The plaintiff must be the one that was aware of the risk. If not aware of the risk, it is immaterial that an ordinary person, a reasonable person, you see, we've come across our reasonable man again. But now our reasonable man is not useful to us. It is immaterial that the reasonable man would have been aware. So the knowledge of the particular plaintiff is what we are talking about. In practice, because I said earlier that under the law, Volenti Non Fit Injuria is a complete defense. If you prove it against the plaintiff, the defendant will not be liable, not pay any damages. But in contributory negligence, the measure of the negligence of the plaintiff is determined by the court, and it is apportioned accordingly. So in practice, really, the courts are more inclined to hold someone contributory negligence than to hold them to be violent regarding this enterprise that they have been undertaking. Because you would see from your cases that the same set of affairs would actually result in either defenses at times. Volenti Non Fit Injuria is useful in sporting injuries. You see our footballers playing and being kicked and falling down. We all love football, boxers, and all sorts of sporting activities where there is physical contact, body contact. The rules of violence apply. That's why you cannot see them coming to court or wrestling or other engaging sports that involve engagements, physical engagements. So you use that to say, okay, you consented to run the risk attendant to that particular sport. But that if someone does anything that is contrary to the rules of that sport, then you would not be able to say that the person has consented. I remember years ago when during a wrestling match, one of the popular wrestlers beat up the hair of his opponent. You can go and research the two of them when from that state of affairs. And out of frustration, just during the boxing match, just beat up the hair, and of course that one suit. That's not part of the rules of the game. So when you don't observe the rules of the game, you cannot say that the person that has participated in the game or is observing the game, like spectators, has been violent, that have consented to run the risk of your failure to observe the rules. So if a spectator, for instance, goes for a football match, yes, you run the risk that if they kick the ball, it can go off the field and hit you. So the ordinary course of playing. Or if a person, for instance, a player deliberately takes the ball and throws it at you and says because you have come to the field, yeah, then you have run the risk, that would not be tolerable. So you have to be able to distinguish those principles. And even with regards to your understanding of occupiers liability, we know that it's a form of liability for the static, negligent liability for the static condition of premises. Volenti would also apply. You see that case in Tomilson and Congleton, where someone had been told that the plaintiff had been told that the lake was shallow and should not dive into the lake, and he still dived into the lake and was injured. It was held that since he failed to obey the rules that were, the notice put on the premises, he had decided to run that risk and should bear the consequences of running the risk. So this is one of the defenses that you could raise in it, against the plaintiff in the tort of negligence. There are ideological considerations and principles about whether it's actually a defense, some of these things that we have called defenses, or whether they are actually rules of liability. But those are issues for consideration in another presentation. For this piece, in this presentation, what we are particular about is the fact that a defendant could raise that against the plaintiff, that this person has actually consented to run that risk. So if you take a lift with a drunken driver, you knew this your friend, you went to the bar together, you drank together, you took whiskey, 7 bottles, and then you decided to drive, and you jump into the vehicle with that person. You could be held to be violent. You run some risk in life that the law would regard as being actually very negligent on your part, for which you should hold nobody responsible except yourself. So the distinction between voluntary and contributing negligence, you would have noticed that contributing negligence is a partial defense, while voluntary non-fit injuria is a complete defense, and it requires that the plaintiff has knowledge of the risk that that we are talking about, and agreed voluntarily, either expressly or impliedly, to run that risk. So in your exams on the tort of negligence, or in the cases that you handle, you should look out for the possibility of being able to canvass an argument in that respect. I'll see you at the next presentation. Don't forget to subscribe and to like this video.